We don't remember the number. Whatever you give, pass on the slip, whatever you mention. Yes. That we can't assure you. Let us start.
With regard to the maintainability with the sample footage.
Sorry, then we'll consider it. Yes. Call the list.
Item number 1.
Item 1, it's a tender matter. Actually, have been in the midst of hearing. I am told, I was instructed by my Mr. Nayak. But today we are for the successful bidder. In the lottery, you have been successful. In the title,
Oh, this is a case of a report. Hey, you have not sent this file to me. I will dictate it today. It was not placed before me yesterday. He has given us some bunch of judgments.
Yes.
So I just go through that.
today, in fact, we are for the successful bidder.
So whatever, sir.
We are not parties.
Only we can extend the compliment to you.
But we are not made parties. We want to participate in the hearing.
How can you, without an application for an
They were applying for this. We are applying for it. That's the reason why I am constrained to disturb Manu.
Yes.
Give us one chance.
This item number 1 of supplementary list.
Yes, yes.
Absolutely.
Equally, we also. But I pray your lordship, give us a chance to assist your lordship.
Whatever you, this is not a way. You'll have to first get yourself implemented, then.
We have applied today.
That is what, if it comes, we'll consider.
But I pray not let it.
No. It 2 days after.
It's not day after tomorrow. Because I will not be there in court. I'll be traveling.
The next Tuesday.
17th.
Great.
Item number 2, WPC 1121 of 2026.
Yes, I think I'm the review petitioner in this case. Yes. I'm the review petitioner in this case. And next one is the order. Yes. I'm the review. Yes.
Yesterday you lost his hard disk. That is you lost your hard disk.
When Mr. Bose was.
Maintainability of the arbiter.
What?
Your question hard yesterday for on the maintainability of the arbiter.
Maintainability of?
Review question.
No, that is not. It is the third party.
Madam, the rest of the process record.
You guys, ready for discussion as well? Are you ready for discussion as well?
This is one repetition, one review petition. In the review petition today listed at the sub item 2 minutes, I was not the petitioner in that report.
That's why I raised the issue.
Right.
Under what ground you can.
Yes.
So far as the retribution is concerned, who is for the petitioner? Mr. Ramnath Acharya?
If not the petition is the review.
I am the petitioner in 1121/2020, which has not been listed. 1121/2026.
Listed, sir.
Listed, sure.
I think this is the first item of item number 2. But you are not following the list.
Yes,
No.
I believe so.
Study you are there, you know, where the matter is listed, so it's not.
the present data application filed only with a seeking direction from the Honorable Court, only to demolish, to vacate the lands, government land, which has unauthorizedly constructed some shop room and also occupied by some discount. That is the my sole ground. In view of the Appeals Court judgment.
Very good. Sir, yes, we'll consider.
Only
That review petition on the ground that the WPC numbers.
It was there, I understand. It was 13 for
It was the judgment was
a subsidy order of.
Yes, it is what was there.
Of injunction, whatever.
Yes.
And one cannot compel to defy that order. but-
Yes, sir. Yes.
That was the reason. Now, subsequent to the entertaining of the review, now that writ petition is also disposed of, interim order gone.
Gone.
What remains?
The next one, the only thing that the admitted fact, and as on date, the writ petition is dismissed, interim order is not there. The question marks in the review petition is that in 3 paragraphs, your lordships have recorded the submission made by the opposite party, who was the opposite party there in the writ
I
petition.
understand. Can it come within the purview of the review?
That is my
Argue.
So, your lordships, my humble submission is that let's.
Have you sought for a leave to review?
Yes.
Application is there?
Yes.
Yes, proceed.
Look at us, your lordships. Very well, it's whether it comes within the purview of the review scope. I'm relying on order 47 rule 1. It says any cross
One is error apparent on the face of the record,
match.
discovery of new and important materials which was not within your knowledge at the time when the judgment or the order was passed, and despite due diligence.
Match.
And those have a material bearing on the judgment itself.
Match.
And third one is for any other substantial cause which has been decided in catena of judgments not to be interpreted in isolation to first two incidences, but it must be related to first two.
Listen, here is a case. The order passed is in the PIL. I am not a party to the PIL. In that PIL, Malats, substantial question which related to a particular plot of land and a construction made thereupon was discussed. That particular patch of land is the subject, and the construction standing thereon was the subject matter dispute before another writ petitions. There are two rounds of writ petitions. Very surprisingly, the first round of writ petition was brought to your lordship's notice that yes, these are the two writ petitions on that particular area was entertained by this honorable court. An order was passed deputing a commissioner to go and survey. The survey report has been produced before the court, and we are taking steps according to the survey report. This was the last argument which was taken on record. However, by the time that argument was made, already challenging that report and non-compliance of the direction passed by the honorable single judge, another two writ petitions have been entertained, interim order was passed, and contempts were also lying. And that particular matter was ongoing. Hearing was ongoing. Counter affidavits files, rejoinder files, that was ongoing.
Are you a party there?
Yes, mother, I am the petitioner there.
So are you supported by any order of the court? Any stuff that you cannot be evicted, you cannot be thrown out? Is there any order is after stage?
At that point of time, yes.
I am asking now.
Lordship may kindly see the order.
I am asking now.
Now there is no order.
So what remains?
The
only thing is that let us be very practical. Suppose if we recall the order review, we can hear out and pass the same order. What it means. Because there is no subsisting order of stay, there is no subsisting order of injunction. The court will definitely, because the law ordains, nobody will be permitted to encroach upon a government lands. If he is produce, then it is the duty of the government, all its instrumentality, all the statutory authorities, all the local bodies to do the work.
In fact, the order I am suffering is against me by honorable
If
single
you have a title better than the title of the local body, you can definitely go and assert it as
the question in the review petition is the way the order has been.
Does it come within the purview of review?
That is my humble submission.
Yes, so that's one judgment.
Malats,
There are two kinds of a review. One is a procedural review, another is a substantive review. You have come under the substantive review, not a procedural review.
Place the judgment before that, Malats, and what provision I'm relying on.
Straight away, we know order 47 rule.
Yes, discovery of facts.
You give a judgment.
Para 12.
I do not think there is any dispute to the proposition which is laid down. But one has to understand at what stage and in what forum.
There is no
Whether the review jurisdiction is a discretionary jurisdiction. I have not
And it's
learned about it, so I just want to learn.
in the
Is it a discretionary jurisdiction?
that's
Is the discretion of a judge whether to review its order or not to review it?
if it let's say if it is
Again,
coming.
I'm asking, sir. Please answer that. Is it a discretionary jurisdiction where some kind of a leverage is given to the judge to review his own order and not to review his own order? Discretion means that he may not. That power is then
If I'm able to satisfy that it is coming within the domain of Order 47 and the ground stated therein, and this on court while passing,
which is, can it come under the error apparent on the face of the record? Was ground. Or does it come under the discovery of new and important document?
that's my submission is that since fraud has been played upon this honorable court, that comes squarely within the purview of.
You can assail that orders in sub-election, whether the review is the appropriate forum for that.
Well, it's the difficulty is the order was passed without having me as a party. Second,
I'm again asking that whether what should be the remedy?
well, the remedy in my respectful submission is if an order has been passed exercising jurisdiction under 226 of the Constitution of India, and well, this court being the court of record, if
I know I'm aware of the Constitution will decision of the Supreme Court. There's a High Court exercising the jurisdiction. Power to review is inherent and ingrained in it. It's no difficulty, I know.
So therefore, my lords, what my
I'm stuck with my own judgment. That's why I'm so much of resilient in this regard.
that's in fact, if I take leave of this court to submit one thing, my lords, in a one of this honorable court, my lords, that was passed by the honorable single judge, writ petition was entertained. Suppression of fact was there. Review petition was preferred. Thereafter, this honorable court heard both the sides of the judgment that whether review jurisdiction is there or not there, and thereafter, after discussing all the judgments, honorable Supreme Court and different high courts, including Karnataka and honorable Delhi High Court, has passed an order that if a fraud from the record on the prima facie note, it has been found that from the record and no analysis or adjudication is required, then the court can review this order. There is no dispute so far as the fact, humble submission is that admittedly on the date when this order was passed, a writ petition was pending and a submission was made. No challenge by any of the parties to the writ petition is pending before any court of law. So that statement itself.
You have not brought the most pertinent judgment, which in the perspective of the fact will have some fear. That will not also help you, but what you are arguing, that is to some extent is discussed. I'm giving Netaji Sporting Club versus PCC by Justice L. Bissen. Yet it will not help you, though it will support you some observations, but it will not help you. I'm just giving you a very clear read.
Let's humbly submit my answers.
So the difficulty is in that judgment also the same situations, complex situation arise. The apex court talks about the scope of a review in that. But now some significant distinction which can be noticed here. that when we are entertaining the review application, the position is really put back. In that event, it's merely an academic to argue the matter. Nothing. You are not supported by any protective order. We entertained because there was an order. Now today the scenario is that there is no protective umbrella. If there is no protective umbrella, then what to do? There are two aspects. Cannot court take a notice of the subsequent event.
Let's say, may submit two things. Two circumstances may arise if I'm not, in this review petition is not entered in. Two circumstances. One,
Suppose it is entertained. One circumstance is this order, because you were not there, record. Second, your right is not protected. The same order will be passed to a victim or to throw you out. Can you stand in the way?
I'll just.
Can you stand in the way?
Well, there will be one difficulty, and the actual difficulty for which I filed this review.
Because you are under the threat of removal or eviction.
That's in the
That's the only difficulty.
in the writ petition which I have suffered today, even if I go and challenge the same, in that circumstances, if this order still stares at me, then, my lords, and there is a direction to take action pursuant to a report, and in that case, my lords, a specific commissioner court's report is in my favor. So even if I go and challenge that order today, I will be suffering this.
Why you did not brought to the notice of the single bench when your writ petition was dismissed, that is in your support. That is an additional fact. You cannot throw my writ petition.
That was there.
It was not there. Then the court has not considered and does not found it any substance in it.
It was there.
Does not found any substance in it. You could have very well taken that particular plea there in the writ.
It was there, my lords. That was the only basis.
The court dismisses means the court impliedly or expressly discarded your contention. Will we not take into account that the court did not find it substantive ground and they rejected your petition? Hence, you have taken that plea.
That is, in fact, that was the primary plea on the basis
So
of
then why did the court dismiss the
the court has taken note of
whatever?
Well, that is a
discarded, not
Yes.
accepted your contention.
but that is still open to. I have a forum to accept that order as on date.
I was expecting.
But
Then why the Malimat committee was constituted because of this? Why it was constituted in 1997 to give his report? Because there was a frequent stand taken at the bar that the moment I have a forum to go up, the court will not proceed to implement the orders. Should not. Must immediately go and sleep in a deep, the slumber. Let it remain. I have a forum. Second thing is, I have approached the forum. Once I have approached the forum, they will not touch. My committee recommended no, which brings two changes in the cities. One is section 115. Another is Order 41, Rule 5, where both say that we are filing an application or an appeal does not tantamount to automatic stay of the operation of the order or execution, unless you obtain a specific order of stay or an injunction.
here is a case where before my fate is decided in the writ petition, the order has been indirectly practicing fraud has been implemented.
I appreciate it, but now the scenario when I am taking up the review finally, the scenario is that it has removed those clouds which were there. Now it's a clear sky, which justifies, had those incidents been there, this order is the perfect order. Suppose your writ petition is dismissed or disposed of, which was done letter of before the order, then it is a perfect order.
My lords.
So today, what remains?
My submission is, had those things been brought to your lordship's notice, this order would not have been passed.
Then it would have been passed today.
So far as
It could have been passed today. Can it not? Because you have no subsisting interim order.
well, there could have been two things. One, the lordship would have given me a chance, had those, and
What more? What chance? That is what we are hearing. What
Right.
chance? What right you have? Tell me.
well, it's,
Have you got any document in support of your title? Show us the deed. Do you have anything which would really throw light on your title to the property?
well, it's what I would have shown to your lordships if I was given an opportunity on
I'm
that.
giving you, show us what you can show.
Right.
Tell me how a person acquires a title in the property. What is the basic document conferring a title in the property?
Well, so far as title, I do not have title.
If you do not have a title, then what right you have to remain? Was there any permission or a lease or any kind of a document executed in your favor
Well, that's the permit.
by the government or a local body? What is your right?
The right-
in the property?
Yes. Well, so far as the right is concerned, in that particular premise, it's not any shop. It's a market complex which was constructed by us with the permission of the local for the 30 years. My content.
Then show us that you have a right to make a construction after taking a permission. The land has been allotted or has been granted to you in this regard. Really?
That's what I'll do is I'll bring that documents on affidavit.
What document? Show us. Don't argue in vacuum.
Well,
I'm
definitely.
telling you.
I'm
To be very frank, I'm immune there for pretty long time. Don't throw something in there.
may submit one thing.
That I may have document, I have a document, and the second day slave face. I just,
Well, it's one submission. The entire case, admittedly, well, those documents are not there.
I'm telling you, there is no such document which has come. That is what the municipality has also come for. Say no such document. Now, if somebody has done an illegal construction, it is a failure on their part that they did not take a prompt and immediate action against that. When the first brick was laid, ought to have been vigilant to go through. Be that as it may, come. Show us your right to.
Therefore, Malas, if your lordship may kindly appreciate one thing, the prayer made in that writ petition, being conscious of that I'm lacking those documents. The prayer in those writ petition was that there were twofold. One, to follow due process of law while doing it. B, that you allot different land because my livelihood is, that was the prayer, being conscious. Malas.
True. Now it is so far as the allotment of alternative place is concerned. It is definitely within the domain of the government or the local body to frame a policy or to adopt a policy. And a court issue a mandamus, adopt a policy.
In fact, Manas, that was not in view of the order passed by the Honorable Single Judge. That extent was not required on the phrase that
We are not concerned, we are not reviewing the order of the single grade. We are simply asking if that is not there, that is not there.
Manas,
And our view is that we can't issue a mandamus to adopt a policy. There are judgments of the Supreme Court which says that the court cannot direct the authorities to legislate something or something which is within their exclusive domain.
well,
Right from Mallikarjun judgments and following something.
that's I'll just place one submission, Malas, that their case of demolishing the existing building came into force on the ground they want to expand the road. That was the case. The report says demolition is required, but partial demolition is required, and totally the shop rooms are not required to be completely demolished so as to have the road expand.
It is, I'm being saying, sir, this creates a larger, then we'll have to expand it. When there is an ample evidence that those constructions are on a public road or a public property or a government property or a property belonging to local body. Partial demolition, that means a tacit consent to remain in occupation over the government property. Can be court directly.
It's so far as my petition before your lordships today is concerned, that is something which is not within the scope of my review petition. And your lordships, the moot question in the review petition is that whether the order was passed taking into consideration the facts or there was suppression or misrepresentation of facts.
Will continue.
That again goes back to.
Yes.
It becomes.
You are doing, you are repeating without understanding. That what is we have to see as on today, what is the situation prevailing now?
So,
I may have a good.
us to go back to difference.
In practicality,
Whatever the fact situations and condition now is. Removed. That's it. No, you have.
All have been demolished except the building of this petition number 1. All have been demolished. All the shop rooms have been demolished except the petitioner's building. No, number 1.
Only one,
Because of
Only one.
tendency of the minor this review petition.
but there was no interim order, or there was a literary.
Yes,
There are different models that can.
I got
This
it.
was.
After your lordship granted interim order, the building was kept.
Have you provided for some alternative?
Minor, this is the, because so many, they are not street vendor act, they are not coming under the street vendor act. They are the financially sound persons and they have let out, these occupying the some, these are let out to others.
The some substances you have not.
But also because that is a big decide.
I'm not asking you because.
No, we have, because spaces are required, yes.
Yes.
Should I give one permission to assist my land friend? Only for 1 minute. My lord,
You're watching.
yes, my lord, your lordship, in this review, yes, absolutely correct in saying that it has become academic by virtue of the order passed Honorable Single Judge, which was a cloud, which was a cover in this before me. But question is, my lord, a person who was contesting the writ petition, he should have brought that fact to your lordship's notice. It is nothing but fraud on the part of the municipality and the state. And we were at your lordship's mercy when we were under the protection of your lordships and of the Honorable Single Judge. But what prevents from bringing to your lordship's notice that there is an interim order in a writ petition when there were parties to that writ petition? And if they are given a scot-free manner, these things will happen in court. And the judicial sanctity of the orders will not be protected, man. Others, it has become academic, your lordship is absolutely
That
correct.
you have yesterday.
That you have. That which would your lordship, at least, I humbly pray your lordship should take the municipality and the state to task for not assisting your lordship properly.
Yes. The instant review application. You would have said.
460, 464, the government group. Only minor, and the read petition may be displayed.
Yes, in view of the discussions made here in our, and the fact that we have already passed the order
Completed with.
in the other writ petition, the instant, the public interest litigation filed by the minister becomes
agreeable or not. We'll draw Lord's attention, my lord, on some of the my writ petition, then my lord, the reply which has been given in context thereof, then my lord, the issue of law. Now, the draw Lord's attention state of in para 13 of my writ petition. Page number 8, my lord, para 13, Roman A. He shows what work in fact I'm doing exercise. Para 13, my lord, it is an admitted fact the petitioner is redeploying the extracted earth in the dike during course of para 13A, my lord.
13A.
Yes. My lord,
It is an admitted fact.
yes, my lord. About my lord. It is an admitted fact that the petitioner is redeploying the extracted earth.
Redeploy.
My lord, in fact, extracted. It is mistake. Yes, my lord. I go down. My lord. It was deployed there.
Yes.
So extracted and deployed. The extracted earth in the dike during course of construction of the ash pond for OP5. So the extracted earth was never used, exploited commercially. The extracted earth was not sent outside or sold to anybody for commercial gains. Rather, the same were redeployed in the construction of the ash pond. Further, such extraction excavation do not require any permission from the authority under OMC rules, which is otherwise mandated prior to use excavation of minor mineral under so-and-so rules. But in fact, when the writ petition was filed, my lord, the matter was remanded to be considered by an arbitrator. Then an SLP was filed, and the issue was framed for Lord's consideration that whether the leviability of royalty would be an issue or not. So that after framing the issue, Lord, the matter has been remanded back to your lordship with request that this issue be decided. Now, Lord, 3rd of August 2023, Lord, my lords framed the questions will be drawing Lord's attention state on para 6. The learned additional government advocate, para 6 of the order dated
Yes.
3rd of August 20, para 6. Mr. L. Samantre, learned additional government advocate, appearing for the state opposite party, contended that though an affidavit has been filed by the additional Tehsildar on behalf
The leviability of the royalty, the same has to be considered by the state.
and they were directed to file an
The
affidavit.
state has an authority to impose any conditions with regard to royalty. The counter was sought.
Counter was sought and counter was filed also, my lord. It was filed in July, my lord.
Yes.
And will draw Lord's attention on some of the paragraphs as to what the best allegation, the worst allegation against me is, my lord. We'll draw, my lord, the affidavit filed on 18th, my lord. This is dated 18th of July 2024.
Like,
My lord, I'm missing the page number now. Page number. My apologies, my lord. My lord, further counter affidavit filed on behalf of opposite parties 1, 3, and 4. Dated 18, it has date 18th of July 2020.
no, it doesn't do. Yes, counter on behalf of opposite party number 3 and 4.
My lord, it is 1, 2, 1, 3, and 4. 18th of
Which is the question? 1, 3, and 4.
Mind.
I find the counter by 3 and 4, two counters.
I'll give the page.
No, I got it. 332.
We'll draw Lord's attention on para 12. 4-5 paragraphs with Lord's permission. I read it out these 4-5 paragraphs. Para 12. Para 12
Yes.
internal page that it is an admitted fact that OP5 is the Power Generation Corporation. LSC lease was granted for said construction of thermal power. For the said purpose, OP5 had engaged the petitioner as a contractor for construction of ash pond and Tilia in the district. The petitioner excavated the earth from land, which was leased out to the petitioner by way of acquisition for construction of ash. It may be noted in the said construction of ash pond, the petitioner excavated the earth from the land by way of engaging different machines, which attracts royalty. So my allegation is that I extracted, so I should pay royalty. Then, my lord, 13 also. That it is an admitted fact that land was granted in favor of so by lease acquisition thermal power plant, wherein the petition was engaged as a contractor for construction, which would be utilized by opposite number 5, and the petitioner had constructed the said ash by way of removing, extracting earth within the lease area granted to the state government. Then, the next part also the similar issue raised before this before the Honorable Supreme Court of India in Civil Appeal number 2235 of 96, wherein the Supreme Court, Honorable Supreme Court has held that use of minor mineral on the railway track after being extracted from the land not coming under the expression bona fide domestic consumption, hence the said operation would be acquiring operation under 2O of Orissa Manor Concession Rules 1990, and consequently embargo contained in Rule 3 of Orissa Manor Rules 1990 makes it crystal clear that railway administration cannot undertake the acquiring operation unless a permit is granted in its favor. Consequently, if the railway administration utilizes the manor mineral from the land for the railway track, it would be bound to pay royalty chargeable under Orissa Manor Mineral Concession Rules. Hence, the present writ petition is similar to the aforesaid Civil Appeal 2235, wherein the railway authorities uses the manor mineral by way of extraction from the land for construction of railway track, which attracts levy of royalty. As in the present case, the petitioner constructed ash pond on behalf of the petitioner for extracting the earth from the land. Hence, it is liable for payment of royalty under the provisions of Orissa Manor Mineral Concession. But at best, allegation again is not that I have accepted.
So the sum and substance of the entire defense is that once you have extracted the earth for the purpose of the construction of a pond, I think that event, if it invites imposition of the royalty under the OMMC.
I go down. Yes,
that's the only.
That is the only.
Now your contention is that you have not removed.
Yes, because
you have not taken out. You have not utilized for any other purpose. Rather, you have stacked those
then and there.
Maybe on the embankment of that particular ash pond or whatever. And therefore, there is no question of any imposition of the royalty.
In fact, there was a change in the rules, royalty rules 1990 and 2004, 2006.
And these were the incidences of
2018. And the judgment which
so OMMC rule already
was amended.
Come in vogue.
It had in 2016, the second, third amendment had come. And the time when I was executing this work, the 2016 was in vogue.
So,
and 2016 does not say that extraction, but initially it was extraction.
What it seems, what is the law on the subject?
Yes. But with Lord's permission, may I read just the charging section first, and then we'll come on the issue.
Yes.
The charging section in this case is 25 of
OMMC.
OMMC, yes, 2016. 2016 25. Subclause 5.
Yes.
Royalty shall be leviable or manor mineral removed from the lease area at the rates specified in so. So removal of from leased area, not removal from pit. And that distinction had come out, my lord, in Rajasthan versus Jint India case, no? That removal means removal from the leased area, not from the pit. That distinction is there. I'll show the judgment to your lordship. So my submission is that mere extraction is not taxable. If I'm extracting it and putting it there here.
Royalties arises only on a removal of a minor vessel, not the
Lease area.
Now, what about the traffic rules?
My lord, I take a responsibility. I go down, lord. Yes, I take a responsibility. Suppose I consume it. But consumption may not necessarily be a change of character. Suppose I make earthen pot, brick, within the lease area, I can be accounted for. But this is not their allegation. Their allegation is that I am extracting. But my lords have rightly posed this question, my lord, if I am consuming it, but consumption necessarily be, my lord, Constitution when Supreme Court brought necessarily.
According to you, that consumption must lead to a transformation of the character, the sticks of that particular or a minor mineral into a final product.
Yes. So there has to have some character.
It is a distinct and separate.
Mine. Like I make a brick. So I cannot, tomorrow I cannot say that I want to reconvert it into earth. That will not be possible at all because the character has already changed. Brick can be converted into a building. So reconversions are possible. For me, not conversion, there has to have some change in the character. That is not the allegation also. And why it is different than 1990, I will draw lord's attention on 1990 also. Will draw lord's attention on
This has already been appealed and superseded by 2016 or 2004.
Yes. 2004, then 2004 almost had, 2016 has adopted 2004. So far my cases, there could be some changes, but so far the royalty definition and the charging section in 2004 and 16 are same.
Font size is very little.
Lord, I tried to get a better one, but in fact, I'm so sorry, Lord. Would be possible only online, Lords. It may be same as others. I give him the same. My Lord is the same. Only possible, my Lord, would be online. Otherwise, I am so sorry, my Lord. Lord, drawing Lord's attention on this room 13-1-3. On which Supreme Court judgment is this? 1-3.
Rule 1-3.
1-3, 13. Liability for payment of royalty dead rent, and will draw Lord's attention on 13 Roman 2. First is Lord Roman 1, the holder of a quarry lease, and then second is royalty. Royalty shall be leviable on minor mineral extracted from the lease date. So that is the distinction.
Yes.
And the Supreme Court judgment, Lord, is based on extraction. So that is the difference. And then the judgment is also based on extraction. That I extracted, so I must pay. And they will draw Lord's attention on the Supreme Court also, Lord. On which, Lord, on this.
What is the generic meaning of the word extraction?
Lord,
what are the removals?
Removal.
Find the distinction.
Lord, the removal can be removed from the pit.
Extraction means something which you
Taken out.
take out.
Yes.
Removal also from the
Taken
original
out.
position you are taking out.
Yes.
In a very common parlance, these two words
I go down.
are understood.
Yes.
Only thing is, you are saying further words which are used from these
Yes.
is a different.
Yes.
I understand.
Yes.
But extraction and removal, are they not?
Lord, extraction or removal, Lord. In fact, now, Lord, I have a judgment, so Lord, I can Lord, assist your Lordship on this regard. Removal from lease area, Lord,
Is a leased area
taken out from the leased area because they say that leased area.
even an extraction?
Lord, the extraction also, as per a layman, Lord, extraction can also be removed. If we take out the lease out area, then extraction and removal can be used same sense. If I'm extracting, then I'm also removing. But the issue is whether removal from pit or extraction from pit. So extraction from pit 1990, yes, acceptable.
Maybe extraction can include digging and extraction and removal, but removal doesn't itself show digging.
No, that is what I was just thinking.
Right.
What you were saying, I was churning my mind into that regard.
Right.
That if the two words, if these two words are used
Extraction.
in a similar manner, if we substitute, then that rule which he is referring of 2016,
Right.
the removal of a minor mineral from the lease field. If we delete the word removal and put the word extraction of a minor mineral from the lease field, I don't think so. It conveys the same meaning.
My lord, by virtue of Supreme Court, my lord, I bow down, my lord, yes, they convey different meanings. Extraction means, my lord, digging and extracting. Whether I'm using, not using, putting it then and there, then, my lord, it's extraction. But removal means, my lord, physically transporting. And, my lord, in judgments, my lord, probably that would resolve this issue, my lord. First, my lord, on the application, my lord, whether how my case is, my lord, different than the one, my lord, referred to here. And then, my lord, the definition of removal, my lord, by the Supreme Court, my lord, in Hindustan case.
Yes, it's an extraction which was used in 1990.
In 1990, my lord. And would have been, my lord, something in mind, therefore they changed the words. Otherwise, the same extraction would have been continued in 2004 and 2016 as well. But they are not using the extraction, so there could be some distinction. I'm not in a position to carve out. But certainly in the mind of draftsmen, some distinction, because they are removing the extraction word by removal. So the substitution would be some intent. Then, one is that Union of India. Hindustan. Note of charging section, which is missing in my case. Para 5.
My brother has also gone into another aspect. Says that the word removal was within the mind of the legislative authorities. It is not that in 1990. The word of removal was not within their mind. Which LD 45 from the definition of what means even there. You will come to the definition of 2M. 2M. If you use both the words.
My lord is pointing out 2M
2M of 1990, 2 new
of 2016. Query lease
values.
means a lease granted on tenure basis for extraction, collection, and or removal of minor mineral other than a specified minor mineral over a time period.
2016.
This is 2016.
2019
My lord.
defines it the same way, means a lease granted on 10-year basis for a period not exceeding 10 years for extraction, collection, and or removal of minor minerals.
My lord.
So the legislatures were conscious of the two distinct features of extraction and removal. Otherwise, they would not have used those words simultaneously, one after another.
My lord, that would be correct.
So that shows that both have a distinct and a different separate meaning to be given.
My lord,
Extraction is not akin to removal.
yes, but my lord, there are two activities. For mining purpose, yes. But whether that, my lord, I might be conducting a mining activity, but yet I may not be liable for taxes. The issue is that, my lord, I'm not running away from the activity, my lord. Presume for a moment that I'm conducting mining. Now, whether the mining activity would invite the liability of royalty, that is the issue. Charging section is missing, my lord. In charging section, the words are missing. So I'm not quarreling with the definition part. I am accepting the definition part.
This these leads, of course, mineral.
15 of the mining is in minerals, right?
1957.
57. Because the section which you are referring of 1990 is relatable to a query leases.
Yes.
So once the query lease is defined, it brings the different concepts. Means the extraction is a independent exercise, collection is another exercise, and the removal is a third exercise.
I go
So
down.
all have to be given a different meaning.
Yes, I go down.
That is what my brother
I go down.
wanted to convey.
Please.
So what is this judgment? This is the removal and the extraction.
But this removal, yes, this judgment is dealing with charging section. That there cannot be any tax in absence of charging section.
Who says under the constitutional mandate as well, unless in the 7th schedule the power is given to the state or the central
Yes.
to impose a tax
So-
or impose any kind of a.
My lord, I go down, my lord. That was the intent, my lord. In fact, I wanted, because they are not talking about the charging section. They simply say that I am extracting, so therefore I should be liable to pay. My submission is that
Then is it necessary to quote the charging section? If one can be reasonably ascertain the charging section from the provinces, simply if they quote a non-quoting of the province in a particular section does not mean that their demand goes.
my lord, in fact, to bring within the realm of chargeability, my lord, there has to have a definition, my lord, because my lord would, my lord, in fact, so far the tax laws are concerned, my lord, there is no role of intendment. There has to have a very, very specific.
No, that's true. In the fiscal statute, we are very concerned about the interpretative tools to exercise.
My lord.
Literal interpretation has to be ensured unless purposive construction has very little or negligible role in it. We are conscious, there is no difference.
Well, that was my humble submission for your lordship, that in fact, if the charging section is not taking note of extraction.
If you take section 9 of the
My. That was amended in 2000, but I'm coming on that. After 2000, the removal has come into change. So that is why now the taking that note into account, 2004 amendment has come. 2004 says removal means removal from the leased area, physical removal from the leased area. I'll read the judgment Hindustan J. I'll come on that. I'm cautious of my responsibility. I'll come on.
Section 9 doesn't say about extraction.
It says of removal.
It says about mineral removed or consumed, right?
But the removal,
Royalty is not a tax.
extraction is not a tax.
No, royalty is not
Royalty
a
is also not a tax.
Royalty now is not a tax.
Now,
No, not now.
there was a confusion only because of the typographical error that has created a 5-judge bench and then ultimately to go to a larger bench. One typographical error.
It should not be, my lord. Otherwise, it is something
Typographical error.
Gujarat
That judgment says not a, royalty is not a
not a
tax,
tax.
but not what was missing, that the ministerial error.
And then 450-page judgment has come just to define that.
It was a one mistake. Because subsequently the 5-judge bench doubted and they clarified that no, what is meant by it is not a tax. Cannot partake a character of a tax.
It should not be, my lord, because this is coming out from a lease, an agreement. There has to have a principle of qui pro quo. If I'm getting something only, then I will pay, which is unlike of tax. Because I'm getting a benefit or not, I must pay tax. My lord, I was just referring to para 5 of this judgment.
Yes.
Para 5 of this judgment, my lord, the Union of India.
Yes.
Read out with Lord's permission. This being the position, the use of manner mineral on the railway track after being extracted from the land, not coming within the expression bona fide domestic consumption. The third operation would be acquiring operation under Rule 2, and consequently the embargo contained in Rule 3 would apply. A combined reading of Rule 2.1, 2 and Rule 3 makes it crystal clear that the railway administration cannot undertake the acquiring operation unless a permit is granted in its favor, and consequently if the railway administration utilizes the mineral from the land for the railway track, it would be bound to pay royalty chargeable under the Orissa Manor Mineral Concession Rules. The liability for payment of royalty accrues under Rule 30. So the conscious of the charging section, that extraction per se is an offense. So under Rule 13, the royalty is paid. Because 13 says that extraction.
This was the case of an extraction.
This was the case of extraction. Even they say that it is an extraction, therefore I should pay. Without consulting Rule 25, that in my case it is not. Then not Hindustan Zinc. This was post 2000 amendment of section 64 of the Manor Mineral, the Central Act. I'll draw Lord's attention on para 26. Para 26. Immediately, may I read it out? Immediately after the offer stated notification dated 12th September 2000 was issued by central government, provisions of Rule 64 of rules and also been amended. By virtue of the said amendment, Rule 64B and C had been inserted with effect from 25th September 2000, which reads as, in case processing of run of mine is carried out within the lease area, then royalty shall be chargeable on the processed mineral removed from the lease area. In case run of mine mineral is removed from the lease area, processing plant which is located outside lease area, then royalty shall be chargeable on the unprocessed run of mine mineral and not on the processed product. Royalty of tailings or rejects on removal of tailings or rejects from the leased area for dumping and not for sale or consumption outside leased area. Such tailings or rejects shall not be liable for payment of royalty. If it is dumped there, then no royalty. Then 27 also. In the instant case, we are more concerned with the provision of 64C of the rules. Upon perusal of the said rules, it is very clear that unless the tailings or rejects are used for sale or for consumption, such tailings or rejects would not be liable for payment of royalty. And my lord, 31.
But you subsequently use it for.
I'm dumping there.
Then in ultimate it becomes.
But if I'm
Why so? So why so?
yes, my lord, in that, but there is no allegation, my lord. With humility, my lord, I'm 101 and 102, my lord, onus is on them.
That mere dumping is not.
I vote on that.
Dumping does not extract the royalty. It is only when you use it
My lord.
that dump, the minerals or some gain.
Yes, that eventually is. The 31 minute are defining the removal minute. From the contents of what has been stated here in above Bagis Court, it is very clear that once a portion of the mineral is returned back to Mother Earth, it cannot be said to have been extracted or cannot be said to have been taken out of the leased area. And when the metal which has not been taken out from the leased area or which is not contained in the ore product produced, it cannot be made subject to payment of royalty because the leaseholder never took out the portion of the metal from the earth, and therefore that cannot be said to be part of metal contained in the ore produced. So I'm not taking it out, Lord. I'm dumping it in the leased area first. This is my case. This is the defense level. Then, Lord, how the other high courts have been treating it, Lord. Will draw Lord's attention on a few of the judgments, Lord, including one Supreme Court, Lord. I'll first draw Lord's attention on Uttarakhand High Court, Lord, in a matter, Lord, which is Jayaprakash Associates versus the state of Uttarakhand. Lord, state of a para 13, para 11. Para 11, Rule 3 of Rule 63 provides that the holder of a mining lease granted on or after commencement of shall pay royalty in respect of any mineral removed by him from the leased area at the rates of for the time being specified for these rules. It means the royalty is payable only by holder of a mining lease.
Which paragraph?
One.
Yes.
It starts with Rule 3 of Rule 1960.
Double one. Oh, there are two double ones. That's
I'm so sorry, Lord. Yes, Lord. This is, I think, the
First one.
Manu Patra. As my Lord. That happens with Manu.
Why not SCC?
My apologies, Lord. Next time I will be more careful. Manu Patra commits mistake.
Para 10, I think.
Para 11. SCC term. No, sir. My Lord has only the.
No, I've got the decision.
Rule 3 of Rules 96 provides that the holder of a mining lease granted on or after the commencement of rules shall pay royalty in respect of any minerals removed by him from the leased area at the rates for the timing specified on these rules. It means the royalty is payable only by holder of the mining lease granted by the government in respect of any mineral removed by him from the leased area at the rates as fixed by the state government. The petition support of the case also produced the judgment given by Division Bench of Allahabad High Court in so and so. The facts of circumstances of the said case are fully applicable to the facts circumstances of the case. Then, my Lord, next 11 also. Under this rule, it is the holder of the mining lease who has been made liable to pay royalty in respect of minerals removed from the lease. So they are conscious of the words removed. And then, my Lord, 14 also. 14 says, digging of the foundation of his own property and using the boulders which were excavated while digging of the foundation neither amounts to mining operation as has been stated in Rule 3.
I think this has been excluded.
Yes.
This has been excluded.
The judgment?
No. This is for building purposes.
That's why excluded by Supreme Court also. Yes. I vote on Supreme Court also already. And promoter builders.
For the purpose of agriculture.
I vote on.
So they are really looking it. They are making it more uneven so that the plants of the sapling or the seed can grow.
Yes.
But they are not removing it. It remains the part of the.
Yes. That one Supreme Court also on the. It was a SLP filed by 4 or 5 parties, promoter builder. In this case, the Supreme Court has very elaborately dealt this issue as to if they are using it and then there, would that also amount to mining activity? draw lots attention on para 13, which is the Nuclear Power Corporation case, similar to ours. In fact, in my employer is constructing a thermal power project. So para 13, 1-3.
I think your junior does not want us to read the full text of the judgment. He is more pro-friendly, does not want to waste.
So sorry, my apologies.
On the reverse also.
I'm sorry, my lord, my apologies.
738, then 740, then 742, then 742. In between, always. See?
We'll draw lots of attention on para 12 of this symbol. No, in fact, my language is not.
No, we're looking at the SSC.
Now SSC. This mine has a Manupata. I borrowed this from my worthy senior because I'm not having, because the paragraphs are not.
You can also do this one. You give me that one, you can take it.
12. Excavation of the ordinary earth.
My lord, just 2 lines above. It is therefore clear that ordinary earth. 12 minutes. Start for it.
Placitum.
Placitum. It is therefore clear that ordinary earth used for filling or leveling purpose in construction of embankments, road, railways is deemed to be a minor mineral. At that time, the law was that it is a minor mineral. Now, Supreme Court is carving out a distinction. It is not in dispute that the present appeals excavation of ordinary earth had been undertaken by the appellants either by laying foundation of buildings or for the purpose of widening of the channel to bring adequate quantity of seawater for the purpose of cooling the plant. The construction of building is in nature of a sanctioned development plan under the MRTP Act, whereas the excavation widening of the channel to bring seawater is in the furtherance of the object of the grant of the land in favor of nuclear power corporation. The appellant builders contended that there is no commercial exploitation of the dug up earth inasmuch as the same is redeployed in the construction activity itself. In the case of nuclear power corporation, it is the specific case of corporation that extract of earth is a consequence of the use of land for the purpose of the grant thereof, and that there is no commercial exploitation of the excavated earth inasmuch as the soil being excavated for intake channel was not sent outside or sold to anybody for the commercial flow. Then 16. In fact, it would be 16, yes, in so far as. Rather 15 also, I'm so sorry, 15 also. As use can only follow extraction or excavation, it is purpose of the excavation that has to be seen. Liability under 48(7) for excavation of ordinary earth would therefore truly depend on determination of the use purpose for which the excavation earth had been put to. An excavation undertaken to lay the foundation of a building would not ordinarily carry the intention to use the excavator for the purpose of filling up or leveling. A blanket determination of liability merely because ordinary earth was dug up, therefore would not be justified. What would be required is a more precise determination of the end use of the excavated earth. A finding on the correctness of the stand of the builders that the extracted earth was not used commercially but was redeployed in the building operation. If the determination was to return a finding in favor of the claim made by the builder, obviously the notification so-and-so would have no application. The excavated earth would not be a species of minor mineral under so-and-so. 16 also. In so far as the appeal filed by Nuclear Power Corporation is concerned, the purpose of excavation exercise being relatable to the purpose of grant of the land to the corporation by the state government. The extraction of ordinary earth was clearly not for the purpose spelled out by the said notification dated 3/2/2020. The purpose undertaken by the corporation is to further to further the object of the grant in the course of which the excavation of earth is but coincidental. In this regard, we must notice with approval the following views expressed by Bombay High Court in Rashtriya Sahara. I'm not quoting Rashtriya Sahara and then granting the exemption. With this note, after that, this is 2014, I think the state of Maharashtra now then brought an amendment that extraction of land, if you use for the lease purpose, this would not be for the purpose of mining. After this judgment, initially, there was a negative judgment. In our case, there is no negative law. In that eventuality, in Maharashtra, there was a negative law. That even extraction of land for purpose of construction of bund, embankment, etc., would be considered as a mining activity and invite community, which is not a case here. Then there are some more judgments of Hyderabad High Court, then Mumbai High Court, then Telangana.
Why multiply?
I'm sorry, then I will, so far my opening submissions are concerned, I'll leave it with permission to rejoin if some more issues arise.
The last judgment, which my learned friend referred, that is a case of promoter and builder association Pune in state of Maharashtra and others. That is the judgment and my learned friend heavily relied on one paragraph, para 15 of that judgment. Now, one line of that paragraph is most important below. That is, the filling up of therefore would not be just what would be required is more precise determination of end use of the excavated earth. But this is important.
It's very, we have also not ruled out.
Yes. Your Lordship, I kindly come to TE of the MNDR Act.
That
Yes. TE. Minor minerals. What is that minor mineral? That is undefined. Means building stones, gravel, ordinary clay, ordinary sand, other than sand used in the prescribed purpose, and any other mineral which the central government may by notification in official gazette declare to be the minor mineral. Now, whether the ordinary earth is a minor mineral, your Lordship may kindly.
no. This is there, Mr. Zahar.
Yes.
I believe there is no further on the position that it will definitely come within the definition of a mineral. The only question is the incident or the act which invites the legibility of the royalty
Yes.
in that event. That is what is the main purposes.
Yes, ma'am. I'll explain that.
Those Rule 25 there, saying that if it is not removed from the ministry, then it does not come within the purview of the liability. But there are two concepts. Yes, minor mineral, no doubt. It is a minor mineral.
It is a minor mineral.
Ordinary earth, ordinary clay, whatever the terminology you use, it comes within the folds of the minor mineral. But what could attract the royalty is the main issue.
Yes, my lord. I'll come to that. I'll go in the sequence, my lord. under 3E, the notification issued by the central government, your Lordship may kindly. In exercise of the power conferred by clause E, T of the Mines and Minerals Fund, so hereby declares the ordinary earth used for filling or leveling purpose in construction of embankment, your Lordship may mark it, in construction of embankment, roads, railways, buildings to be a minor mineral in addition to the minerals already declared as minor minerals herein before under the said clause. Lordship may mark these words.
No, there are two words.
Yes.
Which are to be used. Filling or leveling.
Purpose in construction of embankments.
So that
Now-
sometimes it so happened.
Yes.
Now, take us a hypothetical example of it. There is a lease area which is say around 5 acres of land. There is a low land. There is a low land, one portion of the lease area. There is a high land or a high land in one portion. A person in free, it count those ordinary earth from the high level area. And then dump it within the lease area in a low land, like to make it level.
Yes.
It will attract. It will attract. Yes, the purpose with intention, and it's a paramount intention which is very important.
Yes. Well,
But these will come under the government, but it's, I would say, the exigencies of the loyalty is the issue.
yes, well, I am coming to that.
So filling or leveling,
Yes.
I can understand these two concepts have to be understood in this.
Yes. Well,
Nowadays, there is a complete prohibition of, converting the water body into a full-fledged land for the purpose of habitation.
now, my lord,
Is there any special law here in Odisha?
Revenue laws and revenue law, revenue legislation, water body cannot be. And then Supreme Court.
Interwater prohibition. There is no law.
there are some judgments like
There is a
Jalasaya.
specific law in some state, that's why I'm asking.
Water body is
Which
always.
says that you cannot fill up the ponds, you cannot
Yes.
convert the water body. There is already a PIR pending before the Supreme Court and decisions have been
There was already a judgment of this on
Every High Court should initiate
our
a
High Court judgment is-
suo moto PIR.
Judgment is without Jalasaya cannot be. That is
I
there.
was thinking of that. So you can't do it. But at least the no land, I'm just thinking, just to make it a level.
Yes.
Says that there is a leveling of the entire land.
Yes.
Taking out something from,
Yes, my lord. Had it been a case of only leveling, then matter is different. What is admitted?
no, that comes within the minor mineral.
Minor mineral.
This is what the instance.
Yes.
It's a leveling and filling.
Yes.
On ash, the ash pond is constructed, digging. So it is not for the purpose of leveling.
But it
It is
is
not
used
for the
for the
purpose
purpose of.
Filling. Both.
Yes.
It will remain a ditch. In ordinary sense, we know it a ditch,
Yes.
where they will just store or dump. They use the word dump. The ash, which is the byproduct or the wastage of the plant.
Yes.
So that it does not really affect the air quality, environment or something. Affects definitely.
Yes.
Quality of the earth will diminish. Does it mean, anyhow, what do you want to drive at? Let us.
Yes. Yes. What are the admitted facts in the writ petition? Had it been a case of only dumping, then I can understand what my friend says. that may be acceptable. But if your lordship may kindly see para 5 of the writ petition, that is important. What is the admissions made in the writ petition? That it is pertinent to mention here that from the bare perusal of item 4.1 of the BOP, it can prima facie be ascertained that the petitioner is under the obligation for excavation of earth by mechanical means from the approved borrow areas, either from inside the pond or from outside the pond area. Area outside the pond will be arranged by the contractor at its own cost. From the above scope of work in area, it involves excavating the earth from the land belonging to OP number 5 corporation and utilizing the same for construction of the dike for the ash pond. Construction of the dike. Dike means the embankment. If my lord should look at the literal meaning or dictionary meaning of dike, it is an embankment to stop the water flow. So it is used, it is consumed for that purpose. It is not that the extracted earth is just dumped somewhere. It is consumed and it attracts rule 9, section 9. Section 9 says extraction or consumption. That is the word used.
Removal and consumption.
Sorry, ma'am. I'm extremely sorry. Removal or consumption. Then
Section 9 of the MMDR. Yes.
Then your lordship may kindly see.
Or consumed by food or by this manager, employee, contractor, or service. Beyond the one.
No, it was before the commission.
So,
Section 9. Mineral removed or consumed by him or his
Just-
agent.
Yes. Yes, sir.
Now, my lord, the second question is. Now, my lord, the second question is whether the petitioner can have better rights than the rights which is enjoyed by the lessee who has engaged the contractor.
Narrow the code non-habit.
One,
The legal principle.
legal principle. Now, who is the lessee? Who is the lessee? Well, lessee is the IDCO, Industrial Development Corporation. Now, the state government gave the land to the Odisha Industrial Development Corporation by way of a lease in 2015 for development of that area. Now, 2V of that condition gives only the surface right to the lessee. Now, the Industrial Development Corporation allotted the said land to OPGC, for whom my land senior is appearing, that is OP number 5. Now, OP number 5 engaged the contractor who is the petitioner. Now, what are the contract entered between OP number 5 and the petitioner? Those are also most important, my lord. So, lordship may kindly have a glance to that, my lord. The contract they have enclosed, and so also the request for proposal.
Not that here you are really mixing up the issues. So far as the senior Mr. Vishnu's client is concerned, there is no doubt that he has already paid that royalty to you. It's not that you are suffering anything or something of that. They have paid. Sensing that it is their liability, responsibility to pay the royalty. Yes, you are taking me to that area. We are not into that area. Yes, their agreement, they pay you whatever the statutory liability, deducting from his running bill, and they have paid. No problem. he has come and said that whatever you have done, now nobody has a monetary part, nobody is a sufferer. I think the other sides are concerned except him monetarily. Nobody is suffering monetarily, neither you nor him. But he has suffered a monetarily. He says that since it does not attract any royalty, then why I should be settled with the liability to pay the royalty? This is the question. One is the only question. According to him, if this is the incident which attracts the livability of a royalty, this incident is conspicuously absent. Admittedly, the excavation of the art or whatever the art which has been taken out for the construction of a HARISH pond is being done within the leased out area. He says that removal which is there, which is the charging section or attracting the livability, should be understood in conjunction with the word from the leased area. If it is not from the leased area, and that's not your contention is that yes, the removal is one of the part, no doubt. But if you have consumed the clay, maybe within the leased area, means transforming that ordinary clay into another shape or a character, then it attracts the royalty to be imposed. I believe that's your argument.
That is my argument.
Admission is not necessary, sir. We are on a pure question.
That is a question of law. But what I'm trying to impress upon this honorable court.
If the, like, let us see, if I said extreme case, by virtue of an agreement with you by Mr. Mishro's client, he says that I will pay you this kind of tax. Whereas there is no authority to impose such tax. You say that you have said that every month you will pay me 5 crores rupees as a tax. Now you pay me, this is the tax to me. Is he not entitled to raise that what is the quality of the tax or what the tax is imposed? Whether you have an authority or a power to impose tax, have you imposed the tax? Because without the constitutional authority given to collect the tax, you cannot collect the tax. Even if we agree. So in that event, it all depends. Only thing is whether you can charge the royalty for these, say, blah, 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 blah incidents. That's the question. He says removal has to be understood. The common sense means the removal from the leased area to a outside area, which is not admitted position is not there. I think this is not also disputed by him. He has not taken out from the leased area. It is really there in the leased area.
But it is
Your contention is that here removal from the leased area is not the incident. The incident is if you have consumed within the leased area, then in that event also it attracts.
Yes.
Now we have to decide in that consumptions, any other provision of law shows, and you have shown these provisions.
But I've referred to section 9. Now,
Got it.
then your lordship may kindly refer to the provisions that is under the OMMC rule, the Odisha Minor Mineral Rules, which has been framed in terms of section
Rule with
50
the power of the MMDR.
under the
No problem.
rule 15 of the MMDR.
Has to be.
Now there are two rules. Rule of 2004 and rule of 2016-1. So far as 2004 rule is concerned, that is referred and it is an agreed condition under the request for proposal between the OPGC and the contractor. When the contract was entered between the parties, the 2016 rule had come into force. So now there are two rules, rule 2004 and 2016-1. That is it.
2004 rules have been repealed.
Repealed.
In existence.
Yes.
Can you bring it in existence?
No, I cannot bring it in existence. It remained in existence till it was repealed.
Let us see. Let us see.
Yes.
2004 rules.
Yes.
It says that
2000. I'll first tell you.
The lessee of the area, can lift any amount of an ordinary earth without payment of value. But see,
My learned friend has.
please, when you are talking about two rules are there, I'm giving you an example. Say a particular rule, say 2004 rules for the purpose of example.
Example.
It says that he can extract, remove, lose the clay for indefinite period without payment of money. When actually the agreement, when it came and the law changes immediately, which says complete prohibition of the excavation, removal, and consumption of the ordinary earth without payment of the rent. Now, 2004 Act has gone. I'm talking about the repeal and saving clause, also keeping in mind Section 6 of the General Clauses Act as well. You see, I just before such service. So to that extent, if elections, this is part because every time of setting model is there. And then the actual action when he started for excavation, that was after 2006.
In 18 months.
Came into force. Yes, ma'am.
Then in that event, what will come?
Then your lordship may kindly see.
Will it be governed by the old?
No, it is the new rule. My lord, why I refer to both the rules? Because, my lord, the request for proposal refers to 2004 minor mineral concession rules. But whereas by the time the contract was entered between the parties, 16 rule had come into force.
So it is just 2016 which will govern.
It will govern. But I am not disputing that. So rather I am saying that both the rules, the 16 rule will govern.
Absolutely.
And yes.
Say that.
Yes, ma'am. Your lordship may kindly come to rule 3 of the Mineral Concession Rules 2016.
What is the difference?
Your lordship may kindly come to
Restriction.
weak. Yes, restriction. No person shall undertake any prospecting operation or mining operation or quarrying operation for minor minerals in any area except under and in accordance with the terms and conditions of the prospecting license, mining lease or mining lease or mining or a quarry lease or a quarry permit, as the case may be, granted under these rules. Then the proviso is more important. Your lordship may kindly see the proviso. provided that extraction, collection, and or removal of the minor minerals by a person from his own land for normal agricultural operations or other bona fide domestic consumption shall not be construed as a mining or a quarrying operation. So this is the,
What I say,
yes,
drawing or something, this is excluded.
this is excluded.
So this is also an instrument of excavation.
Yes. And these provisions, if I may argue, my lord, these provisions are in parametry to the provisions which have been interpreted by the Supreme Court in State of Odisha versus Union of India, that is 2000 judgment, where they have interpreted the parametry of provisions. These provisions have been interpreted. Now, what is missing in this rule is the definition of the person, which was earlier incorporated in the 1990 rules. Now, if your lordship will read rule 3 again, no person. Now, who is that person? That person, earlier it was defined under the 1990 rules to be, if your lordship may kindly have a glance to that judgment.
So the person means the money means lessee or a lessee or a licensee.
No, man, if your lordship may kindly see.
This person maybe is qualified.
Lordship may kindly see. That the definition of person which was earlier incorporated in 1990 rules.
I think it's inclusive basis.
Page 430.
It is not restricted. It does not means and includes. It is includes.
If your lordship may kindly see page 4.
This one,
Yes.
1990 rules itself.
Yes.
See,
Rules, your lordship may kindly see.
There is no means. Means and includes. It is not means and includes. Person shall include an individual,
A firm, a company, an association of body, individuals, an institution or a department of the state, central government, so and so, so and so. And that the similar parametry provision is also rule 3, no person shall undertake any quarrying operations. So these provisions are there.
If there is nothing in general clause.
Yes, general clauses is act is there, and I have come up with the
Findings. His whole.
Whether Mr. Senior Misro's client or Padya's client, whatever, this all depends. Who is liable? Question is the event, whether there was any event which attracts the position of the right.
event is consumption.
That's all. So that is your argument. Show us. He has said that the word consumption has not been used in the rules. Rule 25 is silent. It simply talks about the removal from the lease down.
Well, he's not referring to the charging section. Charging section is rule 32.
You are saying the charging section, section 9 attracts.
But section 9 of the act, read with rule 32. 32, my. So lordship may kindly see rule 32.
That's all. Straight away come to on that point. Why you are taking a longer route to reach the same destination.
Because that, why I emphasized on that word person, because it was argued
It's not
that there is
necessary.
a change of route.
No,
It
it's
is
not
not.
that who is that. He has not argued. Yes, show me rule 33,
Rule 32, Your Lord.
32 words.
Liability for payment of royalty, dead rent, surface rent, additional charge, amount of contribution payable to the District Mineral Foundation, amount of contribution payable to the Environment Management Fund. All the lessees for minor mineral other than the specified minor mineral shall be liable to pay the royalty or the dead rent, surface rent, additional charge, amount of contribution payable
It
to
is a
the.
specified minor mineral or.
This is not a specified minor mineral. This is other than the specified minor mineral.
That is what I'm asking.
And it is incorporated in Schedule 2
Yes,
of the rules also.
Yes, yes. Shall be liable to pay royalty or dead rent, surface rent.
Yes. Payable to District Mineral Foundation amount.
No doubt, it's a general clause charging section.
Yes.
What is the event?
But the event is
Remove, I think, the second proviso to some.
the lessee shall pay rent and surface rent at the rate specified in Schedule 1 for all areas included in the lease deed.
Second proviso.
Yes. Provided that the rates specified in Schedule 1 and Schedule.
No. Second proviso, sir.
I'm sorry, Mari. I'm sorry, Mari. Yes, yes. I got it.
Subrule 2.
Subrule 2, second proviso. Provided further that where the lessee becomes liable for payment of royalty for any minor mineral removed or consumed by him or his agent, manager, or employees or the contractor from the leased area, he shall be liable to pay either such royalty or dead rent, whichever is higher. So here also the word consumed has been used. And it is the admitted fact under the admitted fact in the writ petition that the earth which was removed has been consumed for construction of the dike.
Your demand.
But
There is the order.
that, yes, that demand, that there I had one argument below, because the demand was raised to the lessee or to the land allottee. Who is the land allottee? That is the OPGC by the Tahsildar.
You can only raise demand on him.
Yes.
No. On what? Since you have made.
Yes, that I.
Annexure 3 is 4.
That is all.
Please, 1, I think 111.
Triple one and 115.
Both are there.
Both are there.
And it is 6.
6 and 9.
Yes.
Used for construction of the ash pond at Noja, so and so.
Construction of a
Ash pond.
I just heard construction of a S. I was trying. Just continue.
Mention item 4, my lord, and in some difficulty after 3 my learned friend is also here. If
He has also a difficulty.
no, my lord,
Sir.
he is being very kind and accommodating, my lord.
Yes, we'll see to it. Yes.
But no, my lord, it's a great.
We'll not pick up. We'll fix a date.
It's possible.
No difficulty. We'll give. Send one of your associates with you or anybody who's.
Item one, sir.
Yes. Yes, Mr. Das.
So far as consumption is concerned, that is already argued. Section 9, 32, second proviso, 32, second proviso. So the consumption, they also don't dispute. But so far as the royalty is concerned, I'll just show two documents. Their correspondence with the OPGC. Your Lordship may kindly see page 112 of the writ petition annexure 7.
112.
Well,
yes.
There are several correspondence. This is one of them. I need not waste time, my lord. I'm just pressing this. May I please it? Just a small, like, in inviting a reference to this.
Yes, you have I would say, incorporated the word used.
Yes.
In this letter, you have.
No, my lord. This letter addressed by the petitioner to OPGC, and they have admitted to the royalty. That is what I am saying.
This is another. Yes, sir.
In inviting a reference to the subject cited above, we would like to bring to your kind notice that our quoted rate is inclusive of royalty rate 14 per cubic meter. 14 per cubic meter is as per the 2004 rules. On account of sand, earth, moram, crusher, dust, etc. and rupees 50 per cubic meter on account of stone products such as aggregates, boulder, spals, etc. as was prevailing by the time the bid was submitted on 30th November 2006. However, it is a matter of regret that royalty is being deducted at the enhanced rate, which is not fair. That means why I place this document, my lord. They don't dispute the royalty. All that they are saying that we should have been charged in terms of the old rules, not as per the new rules. New rules, the royalty is 35 as per the schedule. So far as the the ordinary earth is concerned, under the old rule, it is rule 40. So they don't dispute the royalty.
Yes.
Now at a belated stage, when the royalty is charged, now they come up with a case that with respect to leviability of the royalty.
But so, that is what the Supreme Court has already opened that issue.
But the Supreme Court has opened.
So
and
can we defy the mandate of the Supreme Court?
No, I can.
We have to decide whether.
But so far as leviability of royalty is concerned, that includes everything. That includes their admission to the royalty. It includes that who will pay the royalty and at what amount the royalty is to be paid.
Yes.
Then, my lord, and so far as the contract is concerned, I'll just show two documents, my lord. Page, Lordship may kindly see annexure. Sorry, annexure 1, page 15 to the writ petition, the relevant page, that is the request for proposal. 50. 15 is the tender document. The relevant portion is at page 22.
22.
Page 23.
Yes.
If my lords may come to the scope of work,
yes.
The scope of work to be performed consists of providing all labor, supervision, materials. The lordship may mark this word material, scaffolding, construction, power, fuel, so and so, so and so. Then the next paragraph, your lordship may kindly. The nature of work generally involves site clearance, including removal of trees, obtaining necessary permission from the competent authority for performing this activity, excavation in all types of soil, rock, foundation preparation, construction of coffer dams, if required, dewatering, showering, shuttering, blackfilling, formation of embankment with material of specified quality. So this formation of material, formation of embankment with specified material, you have used this earth as a material for construction of the pond or the dike of the pond. That is undisputed. And this prima facie shows that it has been consumed. It has been consumed by the contractor himself, itself. And your lordship may kindly see, now your lordship may kindly appreciate, suppose this earth is, although it is extracted, not used, only dumped, then you would have brought this material as per his agreed contract from outside. You would have paid the labor, you would have paid for the material. Now for this extraction, you are charged royalty and you admit the royalty. It is not that you don't admit the royalty, you admit the royalty. And now you cannot turn around and say that no, I am not chargeable with the royalty because I have only used that material and I have only dumped it. Now, my lord, another document, your lordship may kindly see. Page 40, Annexure 2. Page 40 is the contract. After the petitioner was declared as a only one bidder, the contract that is at page 40. Page 42 is the change of law. Why? That is why I was referring to the 2004 rule and 2016 rule. Because 42, your lordship may kindly see the change of law, even subsequent to 23rd November 2016 is applicable. That is there. I'm not placing it, but it is there. Then your lordship may kindly come. I'm sorry, my lord. Page 48. Page 48. Page 48. So lordship may kindly have a glance at the bottom. There is a definition of person. It is similar to the definition which was earlier incorporated in the 1990 rules.
So this is a wide, it's sort of a wide.
Yes.
Connotations.
So he cannot wriggle out of that situation and say that rules are different.
It can be defined in one word.
Yes.
Not only a living person, but a legal person, juristic person as well. That's all.
Right. These are my submissions so far as
Mr. Mishro, if he likes to add or something, because you both are off on a receiving end.
Senior could start, but one judgment, man, where the queries of that 2001 notification was the subject matter of challenge before the Supreme Court in case of Somdat Builders Limited. And the Honorable Supreme Court, lordship may kindly, while interpreting the provisions, it said that earth is a mineral and for that royalty can be charged.
Sir, this has already been decided way back in 1978 in Banarsi Das Chadda's case.
Yes.
Ordinary clay or ordinary earth is a minor mineral. Who disputes?
They have referred to that Banarsi Das.
They have referred.
Yes.
Banarsi Das has been referred.
Has to be. That's the foundational judgment.
Yes.
So this is other than specified mineral
Yes.
as per OMMC.
Oh, this is referred.
Para 24, they have indeed elaborately discussed para 24, 25, 26, 3E of the MMDR Act are also referred.
You have to turn to paragraph 15.
1.5.
Paragraph 15. As my friend was suggesting.
This is a Banarsi Das.
Banarsi Das Chadda, that case has been quoted. And that has been taken the shot.
Yes.
But here, verify one thing for those who actually hear my friend. But we have appointed a contractor to execute the work. There are 4 writ applications filed. The Honorable Court held that the dispute between who is to pay the royalty can be adjudicated by arbitration as per the contract is available in your document. Therefore, whether the liability will come to me or my client or the liability comes to the contractor will not the realm of adjudication so far as the rate jurisdiction is concerned. It's a private dispute between the parties. When the matter was carried to the Supreme Court, 3 writ applications, the matter is there before the arbitrator. There's a 4th one where they raise a point before the Honorable Supreme Court, irrespective whether we pay or they pay, whether payability is there or not. So far as this work is executed.
They raises an issue which strikes at the root of
Right.
the leviability.
So we are not going to interpret the contract between the parties to find out
Obviously.
whether the liability is there or not.
I did not interrupt him. Anyhow, I
So
understand.
that is exactly I say. We will not enter into that. That's the realm between the two which can be adjudicated in arbitration. If at all any dispute arises. Now, so far as the conduct of petition is concerned, he has rightly indicated that's the reason why we paid it. Their later correspondence with us indicates that they also accepted that royalty is chargeable. All those letters, Annexure 6, if the Lordship looks at, page 111, and prior to that also Annexure 3, all those documents show the contractor is aware that yes, I have utilized the earth which I have excavated or taken out for construction of the dike, which is not only unearthed, it is used by other minerals for the purpose of strengthening the dike so that it can be constructed or maybe a concrete wall or built up in such nature that it cannot give up. The heavy ash that will be put inside will not break it. So they utilized it for the purpose of construction of dike, they knew about it. So that's the reason they say that the royalty that has been charged is not, we are not liable to pay, and it is you to pay this. But since royalty has been accepted by him, we deposited because we are the lessee, original lessee. If we don't pay, they will cancel our lease. So we are bound to pay it. After paying, we have written to them that we are realizing from the bill and we have deducted it. So this is our case. Payability or not payability, depending on the utilization of the earth for commercial purpose or for domestic use or for simply stacking in the place. So the nature of utilization, if you looks at their own government, they have utilized for commercial purpose. That is their own government. I'm not going anywhere else to interpret whether it is for commercial use or for any other use. On their own admission itself, I think they kind of now turn around and say it's not applicable. This is only one point that I want to converse with others. And if the dispute hearing who is to pay, it does go to arbitration. There is arbitration clause also.
No, that arbitration is still pending. You said
Other cases, liabilities have been decided, quantification and arbitration will not be awarded in two parts. Arbitrator says, first I will decide the liability, then I will decide the quantity.
Then the between the parties. Only this matter has not been resolved.
That has not been done.
And change of law, anything that should be also interpreted in arbitration, not here.
I will just clarify because some confusion with humidity method has been created. There are two types of earth method. I'm now referring to the provisions of. One was I have to dig then and there, put in the embankment. Second earth I had to borrow from the outside. The royalty I am referring to is respect of the earth which I am digging in the leasing. Not the relevant provision is not even the BOQ item is there below, and there the confusion is being created that look the earth which they are referring to they have to borrow. They say that they will pay the royalty. Yes, I will pay the royalty in respect of the earth which I am borrowing from outside because I borrowed earth from outside. This is the requirement of my BOQ. item number 4.1, which my lords is on page 287 of the paper book, and it says 4.1, 287. Excavation of earth by mechanical means from the approved bore area, either from inside the pond or from outside the pond area. Area outside the pond will be arranged by the contractor. And not the 287.
Yes.
Excavation.
Yes, sir.
So, earth by mechanical means, excavation of earth by mechanical approved bore area, either from inside the pond area or from outside pond area. Area outside the pond will be arranged by the contractor. I am not quarreling so far this participants. I am only in respect of the earth, and they are also charging me in respect of the earth which I am digging it then and there. Because I have paid royalty, I am borrowing from kilometers, I am borrowing the earth. This is not the clarification which we say that why the rate, because contractually I was to pay as per 2004. The contract was signed, my lord, in December 2016, and the laws which were to be taken into account is of November 2016. So this law has come into December 2016. So we said that 28 days before the signing of the contract, so the new law would not apply on me, and the change in rate would be borne by the employer. But that is a different issue, my lord. In fact, intersales. So far, my liability is concerned, the subject matter before your lordship is only with respect to the land, which is the land which was done, which is within the lease area, not in respect of the others. Now, even on the consumption, the Supreme Court Constitutional Bench, they say that 32.2 that they consumed it. Now, please see the definition of consumption, which was rendered by Honorable Supreme Court Constitutional Bench in Anwar. There has to have a change of character. If I am putting it and dumping it, dike is in engineering language. Is the engineering language of bunk, embankment, and engineering language is dike. Because unfortunately, I cannot dig something in air. For digging, I have to go beneath the earth. The moment I am digging, earth will come out. I put it on the embankment. They say that this embankment, you are using it in the embankment. Fortunately, that I am not using. If you say that consumption, because the 32 say consumption, then let's see the definition of consumption. Which is the Supreme Court has not rendered in the constitutional judgment. I'll draw lots of attention and state around there. Para 9. What is the definition of consumption? We say it is in the background of these slides that we have to consider the question whether tobacco was delivered in the state of Bombay for consumption.
Just 1 minute, this one. I'm reading from paragraph 6 on.
May I read it out?
No. Because there they use the word the consumption and use.
Mind.
But in the perspective of 2052 is true. This one, octroi.
This is octroi.
Yes.
Whether the conversion or preparation for salt outside the octroi limits and then bringing it within the octroi limits, that was the question.
But necessarily the character will go for consumption. Use is different issue again.
Yes.
Then Anwar Ali, which is being relied on. Anwar Ali. And just read one paragraph of Anwar Ali. They elaborately defining what is consumption. Because use has a broader term than consumption. Use can be for anything else, but consumption has to have the character changing. This is one of the necessary qualities of consumption.
The raw material goes into the composition of the finished.
Yes, sir.
Raw material goes into the composition of finished product. That is consumed.
That is consumed. So, for example, if earth is there, earth was converted.
Anwar Ali speaks that.
I got on. Anwar Ali is giving an example also.
That example has been set about the cashew nut.
Yes. Then crushing, there has to have crushing something to make it commercially different.
It says even a peeling of the outer coat.
Yes.
And removing the poison therefrom.
It is.
Then it also tantamount to a processing and is a new product.
Right. Because there are different rates also. Cashew nuts, in fact, they have different HNS, HSN code, something like different of cashew nuts. The paractin, they very elaborately dealt with the issue of consumption. Reverting to the instance of cotton, paratin. Reverting to the instance of cotton mentioned above, it will be proper to hold that when raw cotton is delivered in a state A for being ginned in the state, it is delivered for consumption in state A. Where ginned cotton is delivered in B for being spun into yarn, it delivers into consumption in state B. When yarn is delivered in state C for being woven into cloth, that state is delivered for consumption in state C. When woven cloth is delivered to D for being made by tailor in the state, it into wearing apparel, there is delivery of cloth for consumption on state D. And finally, when wearing apparel is delivered in state E for being sold as dress in that state, it is delivery of wearing apparel for consumption in state E, except at the final state of consumption, which consists in using the finished commodity as an article of clothing. There will be noticed at each stage of production the bringing into existence of a commercial commodity different from what was received by the producer. This conversion of a commodity into different commercial commodity by subjecting it to some processing is consumption within the meaning of so and so, no less than the final act of user, then no distinct commodity is being brought into existence, but what was brought into existence is being used up. At one state of the argument, Mr. Pathak appeared to insist that there must be destruction of the substance of one thing before the thing can be said to be consumed. That takes us nowhere because we have still to find out what is meant by destruction of the substance. It may well be said that when a commodity is converted into a commercial different commodity, its former identity is destroyed, and so there is destruction of the substance to satisfy the test suggested by the Learned Council. We think it necessary, however, to enter into discussion of what amounts to destruction, as even without deciding whether there was destruction or not, we think it proper and reasonable here that whenever a commodity is so dealt with, as to change it into another commodity, there is a consumption of the first commodity within the meaning of the explanation so and so. This aspect of consumption was pointed out by Justice Das in so and so. Then the same example, then 11 also, Justice Das here proceeded on the view that using a commodity so as to turn it into a different commercial article amounts to consumption within the meaning of the expansion so in view of which he had earlier indicated so and so. So my submission is that I'm putting it in the dike or in the embankment. I'm not changing the character of the earth. Earth is then and there. So it is not even a case of consumption. If we apply 32, even it's not a case of consumption. The second argument, my lord, by my worthy senior was that I agreed to pay. Now, is he arguing estoppel against law? Even if I agreed to pay, then I have a right to challenge that law. There cannot be any estoppel against law. There are a series of judgments. Even after paying the tax, I can challenge the tax authority's decision. So that is irrelevant whether I agreed or not. There are 3-4 pages, 112, 119, 22, to say that in fact I had agreed that I would pay. That was in respect of a different quantity. I am not fighting with that. There is not even a single document of record related to that quantity, which I borrowed from the outside the lease area. This is only in respect of the earth which was dug from the 38 lines. And mobilize not for
Thank you.
giving me the sheet.
Send it.
Can you show one paragraph? Some clarification, one paragraph. Can you look at page 10 minutes, page 10 of the recapitulation. Their own recapitulation.
What?
So it says in the present case, for clarification, please. In the present case, the earth has been extracted or removed from the land belonging to OPGC. It's not OPGC land. In autumn land, I mean listening. For construction of the asphalt of OPGC, in the such extraction, removal of earth will be bona fide domestic consumption, which is actually not domestic consumption. Exactly, I wanted to clarify that. Of OPGC, as such, could not have been. That's the only ground on which I will say it is not the case.
But word consumption, the lordship just have a glance to this. It cannot be confined only to the change of the character of the material. That is what
Judicially acknowledged and recognized.
This is also judicially acknowledged, my lord. AIR 1963 Supreme Court 906.
Travancore judgment.
Yes, my lord. Burma versus Belgaum municipality.
That is referred to the.
Yes,
That's referred in the subsequent judgment.
Here, change means the earth being used to create.
That has been changed. So that is what is they say. And then make it very usable for the purpose of manufacturing BD. All these things have been taken. The examples have been given. So once the judicial meaning is to be given, that's the legal meaning is to be given, then we'll have to consider when ordinary meaning and the legal meanings are pitted against each other, then what to do? One which will really subserve the very purpose of enacting has to be adopted. So that is what we have to do.
Should we give notes from that?
If you want, you can give a notes. There is no difficulty. Judgment.
Item number 2.
That should be just refresh. Refresh the memory.
My lord, here the petitioner was granted with a release for stone quarry on his private land. And to that effect, one lease agreement was also executed between the state and the vessel, in which there was the clause that deadline royalty additional charge surface rent has to be paid. And accordingly, the lessee has paid for all the dues for every year. That is lease from 2018 to 2023. All on a sudden, my lord, in the year 2020, they issued a demand notice to the lessee without issuing any so far notice that you have to pay a revised additional charge that has to be paid as per Rule 39 of OMMCR, which is only applicable to government organizations. That is in the notice. And in the counter also, they refer to that notification, that is 14/10/2009, which clearly states that it is applicable for government organization. This is my only submission.
And they cannot use this particular provision
Yes, my lord. For another
against a private individual.
Yes, my lord. And my lord, to that effect, I have handed over two judgments, my lord, at the of this honorable court, that if any additional charge has to be given, that is enumerated in the agreement, that is every fortnight, quarterly, fortnight, first
Which
fortnight.
judgment you are?
Yes, ma'am. I'm sorry.
One is our.
Yes, ma'am.
Yes.
That is Shashank Yadav, and another is Sandeep Chandak. That is with regard to enhancement of additional charges member, where it is stated that in the that if any differential amount has to be paid, that is within end of first fortnight, but enumerated in the agreement. And another Shashank Yadav, my lord, that is clause 6.2. Sorry, my lord, that is 5.2. That if the rule is applicable to a specified category of a person and cannot be applied or used against the other category of persons. Never found that judgment.
Which given power was given to the court, if I criminal court, that they can use it. So in that event, it says that if you can't, so that was the case we dictated, so you can't do it, you can't use it.
It is only the criminal court.
Is a criminal court who can do that. So Shashank is not applicable in this regard. Here you are already contention is that the letter or the notification or the circular which they have
issued,
they have used
yes, ma'am,
as the foundation for claiming an additional charges is not applicable to any individual, it is applicable only to a government organization. So this particular foundation is misplaced. If it is misplaced, then it has to go, all the demands. That's your contention is made.
Yes, ma'am.
It is here.
And also the last occasion also I have raised the ground of maintainability limits. The impugned orders in question are appealable orders under Rule 46 of the Act. And
yes, and you have raised this issue.
In our counter affidavit also it is
yes,
raised.
and this matter is pending since 2023.
Yes, no, that's yes. Well, it's on that aspect, my lord, because maintainability is a pure question of law. It can be raised that and
what?
My lord, maintainability being a pure question of
Can
law.
you say that there can be any factor in approaching the court under Article 226?
Yes, my lord. Because my lord,
Maintainability, when you talk about, that means that court will not touch. If the 226 is held to be a basic structure of the Constitution, which cannot be undermined by any legislative effect, how can you say it is not maintainable?
my lord, my humble submission is that, my lord, under Rule 46, there is a specific provision for appeal.
That takes away the power of the High Court under Article 226.
No, my lord, that is not my argument. My lord,
That is when you talk about, you should be very choosy about the word. When you say maintainability is one concept, intertainability is another concept. If you say about maintainability, I believe L. Chandrakumar's Constitution based decision of the 7th judge is against you.
Yes, ma'am. My lord,
It says maintainable. deriving the notion from the Keshwanand Bharti's case.
Well, it's entertainability of a writ petition.
That is the difference.
It's a discretion of the court, my lords.
True.
There is only the factor which can come before my lords is that when there is a appeal provision.
So
Then-
absolutely
Not
suppose if there is a provision for an appeal, that means the 226 is not maintainable.
it is maintainable when there is one arbitrariness in the action, my lords. When, my lords, there is bias, my lords. When there is a violation of natural justice, my lords.
These are all the facets of the maintainability, not a facet of maintainability.
Well, it's
One has to understand this distinction.
Well, it's entertainability, according to me, it's the discretion of your lordships.
True.
And
And on the ground whether the order is perverse,
Yes.
on the ground that the principle of natural justice has been followed or not, on the ground that the settled legal principles have been followed or not. These are all the concept of entertainment.
I agree, my lords. Here,
But you are talking about maintainability. I'm also surprised just to understand that how can you say not maintainable?
my lords, to that aspect, means why I am saying maintainability.
Definitely it is, but interchangeable, that won't throw it out. I will not. You go there, alternative remedy. That's interchangeable.
That's why my humble submission is maintainability, my lords. Here the grounds of challenge, my lords. You have to come back to the writ petition. What are the grounds of challenge? The main ground of challenge is whether the impugned notice demands were in accordance with law.
That again I say that you are confused between two words, maintainability and interchangeability. Whatever you are arguing are the facets of interchangeability. Maintainability means our Order 7, Rule 11B,
Yes, my lord.
barred by law.
No.
It's not maintainable. Maintainability under the Hindu Marriage Act, that the application for divorce under Section 13 cannot be filed within 1 year of the marriage. Maintainable. When the law put a fetter that you cannot file, no suit lies before the civil court against this order. Maintainable. It's under section 9 of the Civil Procedure. Excluded by express or by necessity. 226 cannot be touched from being approached. Approach can be done. Whether the court will entertain or not entertain, it's left. And that too, maintainability after 2023, much water has already flown in the meantime. Can you take this plea at the faggot?
It's to that
When the matter has matured, parties know their position.
to that effect, that question of law can be raised at any stage.
It is not a question of law. Again, I am saying. What is a question of law? One has to ponder upon.
It's question of law meaning whether that question which comes from
No, I will
Manage-
decide, I will dictate that what distinction one has to make between maintainability and interest.
Godrej salary
yes,
has also always the first two. 2020 or 21. And from Whirlpool and
Whirlpool, yes, ma'am.
I mean, that's
Even before Mohammed Noor.
Yes, my lords. Just my understanding, my lords, whatever little I have read, my lords, that the grounds, the maintainability ground, Article 226 can be entertained when there is a violation of natural justice, when the order.
You are correct.
Yes,
That's why now you have correctly used the word entertain.
Yes, ma'am.
When you use the word maintain, then I am put to surprise.
The time for the first time.
But you should take that plea at the first when the writ petition. Now, practically more than 2 years has elapsed. And if again, when the matter is otherwise matured for final decision, can you take a plea of alternative?
My only humble submission in that respect.
Have you got any judgment in your support that it can be taken even at the last stage of the writ proceeding? I know the reverse judgment, but I just wanted to know any judgment in your armory, if it is there.
Let's hand over the judgment, my lords.
Yes.
In 1976,
Yes, show us, I know. Show us which proposition.
Para 11 numbers.
Para.
Then we read para 11, my lords. Before we examine the quintessential aspect presented before us with complex scholarships by the S.C. Mishra, we had better make short thrift of certain questions raised by him. He first desired us by way of preliminary objection not to give quarter to the claim founded on Section 6 of the Act to non-suit his client since it was a point raised de novo at the latest patent stage. The High Court gave thought to this objection and but overruled it. If we may say rightly, the court narrated the twists and the turns of actual and legal circumstances, which served to extenuate the omission to urge the point earlier, but hit the nail on the head when it held that it was well settled that a pure question of law going to the root of the case and based on undisputed and proven facts could be raised even before the court of last resort, provided the opposite side was not taken by surprise or otherwise unfairly prejudiced. Well, that's here because the counter we had specifically taken.
You have chosen a very, I would say, celebrated and most challenging judgment because of the languages and all. To understand the mind is a very difficult task.
I have been reading this judgment.
It's a very difficult task.
Yes, well, I've been reading this judgment to understand each word.
Just give me 30 seconds. I got it. Have you applied your mind in reading the judgment, or you just extracted from the app which is made available to you, and only one paragraph you have read?
Yes, I understand.
Are you sure?
Yes, I know.
Ethics principles will apply here.
And it's next question which my lords pose. I understand the section 6 here specifically was the ground on which there was a maintainability and entertainability which your lordship had explained me earlier. That there was specific provision under section 6 which required that it could not, that it could be non.
Now, second.
Yes, my lords. That I understand, my lords.
When a civil suit is decided, then definitely its maintainability strikes at the root of the jurisdiction, because the court cannot assume jurisdiction to entertain the suit under section 5 or 9. Nowadays, I am finally which says that court will have the jurisdiction unless expressly or by necessary implication or the implied bar. If the suit is barred to be instituted in a court, then maintainability, even at the last stage, that is the point of demur, therefore should be raised. Can you apply these principles into the writ jurisdiction?
Only because of the language which is there in
It is not a language. Language will come because judgment has to be read in the context in which it is used.
Agree, Miller.
If something is decided in a civil suit, then application would be in a civil suit only whether it can be extended to a report.
It's the only reason why I'm relying upon this judgment, Malad, is Rule 46, the language of Rule 46, Malad. Rule 46 is any person aggrieved by an order of competent court may within 1 month the order of the competent court, Malad. Here, Malad, the order is.
Madam, again I am saying, it is a suit or it is a rule if this is there, and then it does not rule out that 226 cannot be called. They were entertaining a suit concerning Section 6 of the Bihar Land Reforms Act, which talks about the right of preemption.
That I understand, Malad. That is the reason I understand the question which was going to be posed to me. But my only submission is that because of the language, Malad, and also Malad,
So a judgment has its applicability or binding efficacy on the language, or it has a binding efficacy on the ratio which is decided in the context or on the facts of the case.
Let's first would be the facts of the case, Malad, because from where the ratio comes, Malad, and in the context in which it is passed, Malad. Malad, my second link from there, if I may just refer to one more judgment of Honorable Supreme Court. Why, Malad, I have raised this issue of entertainability, Malad, because Malad, I'll just read one paragraph from para 27 of AIR 2021 SC 2114, Malad.
You give me that judgment.
Yes, Malad.
Yes. Yes.
Para 25.
I think this time my brother will react. Salah?
25 minutes.
Yes.
25 minutes. Page number 10 of the.
Yes. Please number.
Para 25 minutes. They rely upon verbal to my lords to say that.
Well,
yes, my lords. Verbal to say when it can be entered. It is on three exigencies which has been mentioned specifically where there is an enforcement of fundamental rights.
No, paragraph 25.
Paragraph 25, they refer to verbal, my lords.
Correct.
Well, it's only the page number 11, my lords, next page, my lords, where they say on what. I'll just read, my lords, the bold portion, my lords, and then come to para 27, why this conclusion have come, my lords.
As a junior member of the bar, I invite you to read the whole of the paragraph. Do not read from the middle.
Apologies, my lord. Well, it's para 25 minutes. In this background, it becomes necessary for this court to dwell onto the rule of alternate remedy and its judicial exposition. In Whirlpool Corporation, with its Registrar of Trademark Mumbai, reported 1998
2 judge.
Yes, my lords. In that para 15, my lords, which has been quoted, my lords.
Under Article 226.
Yes, my lords. The High Court, having regard to the facts of the case, have discretion to entertain or not to entertain the writ petition.
True.
But the High Court has imposed upon itself certain restriction on which is one of which is that is an effective and efficacious remedies available.
Correct.
The High Court would not normally exercise the jurisdiction,
Correct.
but the alternative remedy has been consistently held by this court not to operate as a bar in at least three contingencies, namely where writ petition has been filed for enforcement of fundamental rights. My lords, here there is no such case made out, my lords. Second, where there is a violation of principal naturalism, this is also not made out in the writ petition. Or where that order of the proceeding are wholly without jurisdiction or wires of an act is under challenge for this. And then, my lords, para 27, my
What
lords.
is the meaning of this last one?
At least. Proceedings are wholly without jurisdiction.
Correct.
Well, it's
What
here-
is the meaning of this?
Here, respectfully, my lords, the proceedings are not wholly without jurisdiction.
If the action is contemplated on a particular section which is not applicable at all, will it not tantamount to without jurisdiction?
No, my lords, that facts, my lords, it may give me 2 minutes and I'll come back to facts, my lords.
When you have raised this issue, that's what I
Yes,
have.
I'll come to that.
So now you have to.
Yes, ma'am.
Then
Ma'am,
these are the, according to you,
Yes, ma'am.
these are the three principles.
Yes, ma'am.
There cannot be any fourth principle.
My lords, these are.
No, I'm asking. So only three principles,
My lords, yes.
not fourth or a fifth.
Well, perversity and arbitrariness is always there, my lords. I cannot
So that is the fourth principle.
shy away from that, my lords.
Illegality.
Illegality will
Illegal-
come under, my lords, arbitrariness, perversity. I cannot shy away from the fact that there is arbitrariness in the, on the face of it. And my lords, in para 27, serial
Yes.
number 5, the same thing is repeated, my lords.
Yes.
That when a right is created by a page number 12, my lords, para 27,
Yes.
Roman 5, my lords.
Yes.
When a right is created by a statute which itself prescribes a remedy or procedure for enforcement of the rights or liability, resort must be had to that particular statutory remedy before invoking discretionary remedy under Article 226 of the Constitution. The rule of exhaustion of statutory remedy is a rule of policy, convenience, and discretion, my lords.
So,
Well, it's now, if I may come to that
but we have not read the second one. You straight away that's jump to the last second one.
Yes, my lords. My lords, I'm not denying this fact, my lords, that
Why not one?
Yes, my lords, that. My lords, my only humble submission is that.
What is the word? Maintainability is used or entertainability?
Entertainability, my lords. Entertainability. My lords, coming to that question, David, my lords.
You have filed a counter?
Yes,
Can you show me a judgment that after filing a counter, alternative remedy points will be taken?
Specific judgment, my lords, to be fair means I tried finding, but I
You will
could
not find, that's what I am saying. Rather find opposite to you. But you will not cite those judgments.
I could not find, my lords, to be very fair. I tried.
Opposite to it, you could not find.
So there were few judgments.
So
Like,
why you did not cite that?
because the only difference between.
That is what the fairness, the member of the bar should show.
Only difference I
If
could.
any judgment which is also against must be brought to the notice.
To that effect, the only difference I could find in those judgment in this matter is that here we had specifically taken a ground of.
At the time of an admission
That is not.
or at the first innocent stage. That is what those line of judgments are. Or even not. Anything?
It's only 2 pages, my lords, of the counter affidavit, page 12, which is the fixation or realization of additional charges, why it was made, my lords.
Page?
Page 12 of the counter affidavit filed on 3rd November 2023 by opposite party number 2 and 4, my lords.
No? Yes. Yes. Yes, you are referring which?
Page number 12, my lords.
What? These kind of.
Turning page number
This is
103.
counter, this is.
Running page number 103 minutes. Running page number 103 minutes. Or page 12 of my counter affidavit.
Yes.
This is a letter dated 24/9/2020.
Yes.
If I may read this, my lords,
Yes.
in inviting a reference to the subject cited above, I am to say that on the report of the sub-collector Jharsuguda regarding settlement of 11 number of minor mineral sources beyond the scope of OMMC. In this case, my lord, admittedly, there was no option. And all these leases were executed after OMMC 2016 had come into place. my lords.
Illegality, I think, it started from your action.
Yes.
Then
Has been pleased to order for fixation of additional charges on the rate of royalty assessed during the time of settlement of these sources under Lucknow Tehsil. The additional charges may be calculated, my lords. I am emphasizing on the word may be calculated as per the instruction issued in our revenue disaster management. This revenue and disaster management letter refers to Rule 39(5), my lords, which refers to government companies. My humble submission would be here we have adopted that calculation, my lords. We have not referred to that calculation, my lords. And my lords, under in the contract document also, clause number 4 states that lessee shall page number 46 of the writ petition, my lords.
yes.
Lessee shall pay royalty in advance and the differential amount, if any. And this language is borrowed from Rule 32 of OMMC rules, my lords, which also talks about additional charges, my lord. Here, what we have levied under the impugned order is additional charges. The basis of calculation is the 2019 notification of revenue, which refers to 39(5), my lords.
When is that, that 39, Rule 39?
Yes, ma'am.
Where is that?
My lord, it is in the OMMC rules. There is no calculation has been given.
No, OM.
Oh, Odisha Minor Mineral Consensus Rules 2016.
OMMC rules.
See rules.
Right. Mm. Yes. And where is that letter that you disclosed? That letter?
Page number 10 of my counter affidavit.
That letter which is referred there.
Yes, ma'am. Page number 10 of the counter affidavit.
It is 14/10/2019 instruction.
Running page number 101.
Page number
101, running page number 10 of the annexure A by 4. Yes.
Submarine pipes.
just looking at the region. Yes. Yes.
Yes, my lord, I want to show again the 24/9/20 letter, which was issued from additional district magistrate to Tahsildar. My lord. The tenure of this letter, my lord, it is said that in inviting a reference to the subject cited above. Yes, my lord. That is in the counter.
Page number 12.
Page number 12. That is 24/9/20. On the basis of that, they have issued that instruction. 14.
I understand. They have
Yes,
said
my
that calculate
My lord,
out of
here
that.
the collector has been pleased to order to fixation of additional charges. First of all, collector has no authority to order for fixation of additional charges.
So who
That
is
is
the-
Tahsildar. Tahsildar is the authority under the statute, my lord. And my lord, what they have stated on the rate of royalty assessed during the time of settlement of these sources. My lord, while the settlement of these sources, they could have imposed those royalty and they have imposed. Additional charges has been mentioned, royalty has been mentioned, and we have already paid all the dues, my lord. Now they have come up with such an instruction that this additional charges has to be calculated on the basis of royalty for this after average of the highest additional charge bids received during last 3 to 5 years. My lord, this is not conceived under the rule. From where they got this idea to fix the additional charge
Got it.
as the average of.
Under the OMFC rules, apart from 39, where are the provisions relating to the additional charges to be
Yes.
paid by the mining DC?
32.
32 is applicable to which
32 is applicable.
specified mineral or is a general one?
It is for general minor.
Other than
Other
the
than specified minor mineral.
and your one is other than the specified minor mineral. What is
No,
it?
my mineral is at signal number 2. That is boulder energy.
It is otherwise the specified minor minerals which are given in schedule 1 actually.
Yes, my
So you are coming under schedule 2.
schedule 2, my
So other than the specified
Yes,
minor.
Yes, 37.
32 talks about the additional charges.
Yes, ma'am. That we have to pay royalty, bed rent, surface rent, additional charge, amount of contribution payable to the DMF, amount of contribution payable to the Environment Management Fund, and fees for compensatory afforestation. My lord, we have already paid all the dues.
Yes. It's okay. Yes.
It's against you.
Actually, my lords, I'll give it right now. I'll send you.
Okay. And I'll,
No, we will give. I have those with me. No difficulty.
I could also provide, my lords. I have it in the system, my lords.
just to have.
Very nice.
The not other letters.
My lord, pursuant to that, when my first writ petition was rejected before this honorable court, it was sent for to consider my representation. After considering the representation on the basis of these two letters, they issued an annexure 1. On the basis of these two instructions.
Connection 1 is
Annexure 1 at page 16.
1/6.
Yes, ma'am. That is clearly at 1, clause 1. The demand notice issued in which Tahsildar Lakhanpur Taylor found that paragraph.
Okay.
Yes, ma'am.
So you was seeking to cause this letter.
This annexure 1. They have combined all the demand notices.
So this is the 27/7/2023.
Yes, ma'am.
Huh?
Yes, my lord.
And what about the 24/1/2023? What is this?
My lord, those are the demand notices, my lord. That is at page 73. Those are demand notices. So page 73, ma'am. Annexure 12.
So those are there. And 26/11/2020.
24/1/23.
26/11/2020. Prayer 3 notice. You wanted to.
My lord, that is also 26/11/20. That is also demand notice, my lord.
Also.
That starts with this first one.
7/3/2022.
Hmm?
Fourth prayer. Fourth prayer.
My lord,
7/3/2020.
17.
7th March.
Yes, my lord. That is my letter moved before the authority for passing those additional demand charges.
So you wanted your letter to also be quashed. If it is your letter, then why you want this letter to be quashed? Where is the annexure being?
Page 62.
What is that letter? Page
62.
Annexure 8 is 62. That is reply to the demand notice.
And you have asked for quashing of this letter as well. This is your letter.
Yes, my lord.
You say that with regard to this shall not be quashed. What is this 5?
Manage Annexure 7 is also letter dated 7/3/2022. Manage.
7.
Yes, Manage. Page 59. Manage. That is a demand notice.
7/3/22 is the notice, my lord, demand notice.
You have said annexure 8, so that's why is your letter. Oh, this is that letter. Then it is wrongly printed as annexure 8.
That's
Sir,
which is.
what about 24/6/2022?
It's also notice, my lord, annexure 10 series 66-68 notices.
Notices demanding the additional charges.
Yes, ma'am. Demand calculation, all those are given at page 66.
These are all the reminders notices.
Yes, ma'am. Yes, ma'am.
Reminder notices.
Everything
Calculation along
with the order measure is at Annexure 1.
Yeah. These are the reminder
Yes.
demand notices.
Yes, ma'am.
And you want it. And you do not want to quash 24/9/2020 letter.
Yes, ma'am.
It was
If it's not has done it, the
The second case is also said. The three matters are tagged minor in this case.
They will take care of. Only thing is the query name will be different.
Another submission, the third matter, there is a difference.
What?
Only interest part which has been, they have demanded, that is beyond lease period. And before that, when that lease period was not.
Then we will hear on the other day. We can't. The two matters which are similar. You see, and he carries this other one and keep it in the next week. We'll hear.
1,17,000, only that much.
1,70,000 is negligible for you.
Lease period. That is beyond lease period, when the lease.
Then we'll have to apply on the. We'll hear you.
Yes.
The last 32200.
That's both the matters.
Man.
Yes.
Item number 3, the next one. Mr. Dillai.
I'm ready, Lordship.
Can you?
That's why, Lordship.
3 minutes.
Let it be.
Because today is a hearing day. So what I have decided, or rather us, we take up the hearing matter and dispose of then and then. And you have seen from the morning.
Lordship, that is. But I'm still disposal, Lordship. One disposal can also cover 100,000 matters,
So
Lordship.
that is what we are keeping on the next day as a first matter and then decided.
Lordship.
21 matter which was. What is that?